We're going to talk about a big update in the Marcellus Williams case. He's been appealing his conviction for many, many years. He maintains an argument of actual innocence. He is not the one that did the crime that he's convicted of. The Innocence Project has been alongside him for a decade, helping him fight the fight. He was about 60 minutes away from execution back in 2017 until the former governor of Missouri stayed the execution. He was set to be executed on September 24th, and that is no longer the case. His life is spared, although the Attorney General is still insisting that they want this man to be sentenced to death and executed for once and for all. But what actually happened? Because unless new evidence arises or laws change, he can't ever make an appeal for his innocence again. This morning, for the first time ever, a court was supposed to finally hear evidence that proved his innocence. And a few hours in, it was delayed, and it was said that the attorneys had come to some type of consent agreement. And here's the final consent order and judgment. Let's see what it says. So, Marcellus Williams v. State of Missouri, consent order and judgment. Marcellus Williams was charged and convicted in St. Louis County, cause number 99CR-5297, with 1 count of murder in the first degree, count 2, 1 count of first degree burglary, count 1, 1 count of first degree robbery, count 4, and 2 counts of armed criminal action, counts 3 and 5, and was subsequently sentenced to death on count 2 on August 27, 2001, along with consecutive terms of 30 years for count 1, 30 years for count 3, life for count 4, and 30 years for count 5. On January 26, 2024, the state of Missouri filed a motion to vacate or set aside judgment and suggestions in support pursuant to Section 547(31). This court set a hearing on this motion for August 21st, 2024, today. This court has been informed the state of Missouri, through the St. Louis County Prosecuting Attorney and Williams, have agreed to settle this matter as follows: that the conviction and sentence as to count 2 only shall be vacated. So only murder in the first degree is going to be vacated, conditional upon Williams pleading to the charged offenses of murder in the first degree pursuant to North Carolina v. Alford. So they want him to take an Alford plea. An Alford plea is a way that a defendant can maintain their innocence, but acknowledge in a way that, look, there's evidence here that would probably result in a guilty conviction. With a negotiated sentence of life without the possibility of parole for the charge of murder in the first degree, with the other counts, upon which Williams was found guilty after a trial and subsequently sentenced, remaining unchanged. So, they're redoing the plea on the first-degree murder charge. The court finds that the state of Missouri, through the St. Louis County Prosecuting Attorney, concedes that constitutional errors did occur in the original trial that undermine confidence in the original judgment. The court finds that, following discussions between a representative of the victim's family and both the prosecuting attorney's office and the attorney general's office regarding this consent judgment, the court held a telephonic conference in chambers with that representative on August 21st, 2024, wherein the representative, so the family's representative, expressed to the court the family's desire that the death penalty not be carried out in this case, as well as the family's desire for finality. The court has been informed that Williams acknowledges, understands, and agrees that by being resentenced in this new term, this Alford plea, pursuant to this judgment, in this consent order and judgment, he waives his right to appeal or collaterally attack the judgment resentencing him following the entry of this judgment, except on grounds of newly discovered evidence or changes in the law made retroactive to cases on collateral review. The court finds that the state of Missouri, through the St. Louis County Prosecuting Attorney and Williams, are the proper parties to this negotiated settlement of this matter pursuant to Section 547(31). The court finds a consent judgment is a proper remedy in this case. The court further finds, in accordance with revised statute of Missouri 547(31)(2), the Attorney General has been given notice of the motion to vacate previously filed, has entered its appearance, and has participated in all proceedings to date, including providing its objections to the instant consent order and judgment. The court, after taking judicial notice of the motion to vacate, the evidence presented at the original trial, direct appeal, and post-conviction proceedings, including all state or federal habeas actions, finds this consent order and judgment is supported by the record. The court further finds that all other pending matters or motions before the court in this proceeding are hereby denied. Wherefore, the court vacates the conviction of Marcellus Williams for murder in the first degree, count 2, on the condition that Marcellus Williams accepts a plea of murder in the first degree and a sentence of life without the possibility of parole be imposed. So is ordered today, 8/21/2024, and signed by Circuit Judge Bruce Hilton, as well as Marcellus Williams. And so Shawn Malone was doing reporting on this today, and this was particularly interesting to me. At 3:08 p.m. Eastern, Shawn Malone posted that, breaking, St. Louis County courts announced the DNA evidence meant to exonerate Marcellus Williams has been mishandled, and at some point, DNA was added to the murder weapon. It no longer exonerates him. So this could be a big factor in why, after fighting so long for actual innocence, Marcellus Williams might have just decided that was the thing that I hoped would be the new evidence that would overturn my conviction. That's not on the table anymore. I've got this looming September 24th date on the horizon. I'll choose life. And so for me, this is a case I've paid attention to for over 7 years now. I remember the day that his execution was stayed. Everybody was tweeting about it. It was trending, and it was like the final minutes. And you think it's over, and then finally the execution was stayed. So after I started doing this YouTube channel, I was like, I love the Innocence Project. I love the work that they do. I was like, I've got to talk about Marcellus Williams' story. So I had done a deep dive, and you can take a look here. I'll link to it in the description. It goes over a lot of the same stuff that sort of referenced in this consent order, including the habeas corpus petition, writing to the Supreme Court, really good writing. Some of the initial reports when, the investigation into the death of Felicia Gale was underway, before they actually had a suspect. Some information about the trial. A lot of stuff we go through in this deep dive here. And then about a month after that, while Wesley Bell was still a prosecutor, he recently just won an election, so he's changing roles, but while he was a prosecutor, he actually filed to vacate the conviction of Marcellus Williams. Like actual innocence, vacate the conviction. And so we had done a deep dive live stream on this here. So I'll link to those two things in the description, tons of information in it if you're unfamiliar with the story and would like to learn more. But there you go. Let me know your thoughts, you guys. This is the story. Now, I guess, a closed chapter for Marcellus Williams and his fight for innocence. You guys all take care and see you next time.